Hi friends, today we're going to be talking about stare decisis and the doctrine of precedent. So just a bit of context before we go. The doctrine of stare decisis is let the decision stand. Precedence is the principle that judgments are to be decided the same way as in previous cases to create a uniformity in law. Let's go see what some of our friends think.
Well, my friend forced me to be here. So, today I'm going to be talking about what precedents are. So basically, a precedent is the reasoning behind a court decision that establishes a principle or rule of law that must be followed by other courts lower or in the same court hierarchy when deciding future cases that are similar. And we have the original precedent, the binding precedent, and as well as the persuasive precedent. So I'm going to be providing brief details about the original and binding. So basically, the original precedent applies in cases where the point of law has never been decided before. It is the first time where the precedent is acted upon, as there are no past cases where a decision can be based on. In short, it applies to creating a new legal rule. So when you look towards the binding precedent, it's a precedent that is applicable in a later case, and something is said to be binding when legal obligations are involved. This precedent is used when the facts of a case are somewhat the same with the decision of a higher or same level court. When it comes to determining a binding precedent, there are a few criteria you have to follow. Number one, only decisions from higher or courts in the same field can establish a binding precedent. And number two, the facts of the previous case must be relevant and correlate to the present case. An example of cases that relate to this are the cases of R&R and also Donahue and Stevenson. So for the case of R&R, it's basically a case where the original precedent had come about, where the facts of the case were where the defendant had some matrimonial issues with his wife, and which led to the wife to leave their house to stay with her parents, but they were still technically married at the moment. And one day, the defendant barged into the house and forcefully attempted to rape his wife. And this issue was brought to the courts where the defendant submitted his appeal, where the offence of forcibly sexual intercourse without consent does not apply in so-called matrimonial homes at that point of time. But it was held by the courts that this appeal was dismissed as rape is still rape regardless of the social or environmental context revolving around it, which gave birth to a new precedent where matrimonial sexual offences are also enforceable, which means that in this case, it shows that original precedent was applied as it was the first case of its kind. And the second case also that I'd like to talk about is the case of Donahue vs. Stevenson, which was the original case which introduced the modern principle of negligence and the neighbour principle as we all know today. And basically what happened in the case was, a short summary of the case is that the defendant, Mrs. Donahue, ordered a ginger beer in a cafe, and as the cup was in a non-transparent bottle, the contents couldn't be seen. So she carried on talking to her friend and eating and so on, and after she finished half of the bottle, she discovered that there was a decomposed snail in the cup. And due to that, she suffered a personal injury and brought the issue to court to sue the manufacturer. And her claim was successful, which brought into effect the original precedent of the neighbour principle.
That's an interesting idea. Let's see what our friend Vino has to say.
Hi friends, I'm Vino. Today I'm going to talk about the persuasive precedent. Unlike the first two precedents, persuasive precedent is slightly different. Persuasive precedents are precedents that are not binding on certain courts. A persuasive precedent is not binding, but it contains other factors which causes their decision to be influential. A persuasive precedent can be followed, but there is no compulsion for the courts to do so, provided there is no binding decision exists for that particular precedent. It can be used if there is no proper binding precedent in a place. There are a few sources for persuasive precedent. The first one I'm going to talk about today is about the courts lower in hierarchy. Normally, a precedent comes from the higher courts, but for persuasive precedent, the higher courts can take the decisions from the lower courts into consideration to decide a case. For an example, the case of R&R, where the decision of marital rape was decided in the lower courts, and the same reasoning was also given by the House of Lords, deciding that the marital rape is an offence. This case shows that House of Lords agreed with the decision of the lower courts. The second one is the dissenting judgment of the judges, where what is dissenting judgments? Dissenting judgments are decisions which are minority. A judgment for a case will normally be decided with reference of the majority decision. If there are 3 judges, 2 are in favor and 1 has a different opinion, then the one judge will have to provide his reasons for his dissenting judgment. If a similar case comes before the court, the dissenting judgment could be cited in the case to see if this could be the correct decision. This also applies to the decisions that are not ratio decidendi. Ratio decidendi are basically the reason for the decision. It comprises the marital facts deemed relevant and the legal principle applied in arriving at the decision. So the material with lower ratio may be used as the persuasive in other cases similar like the dissenting judgment. The next one, we will look at the cases from courts in other countries from common law jurisdiction. Example of common law jurisdiction are the cases from the countries such as Australia, New Zealand and Canada. These common law jurisdictions are used to persuade the courts to follow what has been decided in this jurisdiction. Lastly, I'm going to talk about the obiter dicta. Obiter dicta are comments made in passing. This is not necessary to decide the issue before the court. In many instances, such statements arise as the judge speaks of hypothetical situations which do not arise in the case in question.
That's pretty cool. Let's see what the other friend thinks.
Hi, my name is Stephanie. Today I will going to talk about the advantages and disadvantages of judicial precedents. The doctrine of precedent is an important feature of judgment law. There are both advantages and disadvantages of the doctrine of precedent. And advantages of precedent is that there are consistency and uniformity in the application of law. As the courts will decide and treat the cases with similar facts in the same manner, unless other facts is material to the decision, so that the courts will reach a different conclusion. Lawyers are able to advise their clients in their situations with certainty in similar cases to predict their outcome before the cases are brought to the court. Injustice will also be prevented as the court will reach the same conclusion for the cases with similar facts, and it society's confidence in the justice system. Furthermore, another advantage is that the decisions are based on principles, which means that the judges are prevented from making mistakes and producing poor judicial decisions, as the guidance will be provided as to deal with the cases. The ruling of judges will be consistent since judges will be bound by the previous cases from the higher courts. Therefore, the court's decision is difficult to be contested, so the integrity of the justice system can be preserved. In addition, the judicial precedent is flexible, as there are ways to avoid precedents and higher courts can overrule the previous cases. Besides that, judicial precedent is also time-saving. Cases with similar material facts can go through the lengthy process of litigation. However, in other hand, the judicial precedent do brings disadvantage as the modern society has developed over time. Some areas of the law are unclear or in need to be reformed. The judges still have to follow a binding precedent even they think it's bad law or inappropriate. For example, the lower courts have to follow the decisions of higher courts. Court of Appeal has to follow its own previous decisions. Bad judicial decisions are perpetuated for a long time. Before they come before a court high enough to have the power to overrule them, this has highlighted the slowness of growth and precedent rigidity, which makes the law inflexible. Besides that, it increases the complexity of cases when the volume of case law decisions are too big. It will cause confusion, increase the difficulties and complexity of cases, and consume much time to decide the ratio decidendi. Also, the advantage of certainty can be lost if there are too much illogical distinctions between cases. It will be hard to find which precedents will be applied to the case.
Right, that's pretty interesting. Perhaps what are some ways that judges can deal with precedents of court?
Hi, I'm Emilia Nadira, and I'm going to be talking about the methods that judges can use to avoid precedents. So there are 4 methods of avoiding precedent, and the first one is to follow. This means if the facts of the case are significantly similar to an existing precedent, then the judge can always just follow the decision. The second method is to overrule. Overruling a precedent happens when a superior court decides not to follow an earlier precedent established by a lower court in a different case that also has the similar material facts. It can do this because it is not bound by the precedents created by the lower courts. Therefore, the superior court could overrule the previous precedent, and when a precedent is overruled, the new ratio decidendi from the latest case becomes the precedent to follow in the future. So new precedent is set. An example is the case of Ants against Merton London Borough Council being overruled by the case of Murphy against Brentwood District Council. In the case of Ants against Merton London Borough Council, the ratio decidendi of the House of Lords was that the purchasers of the defective buildings could recover compensation from local authorities when the defects were due to negligent inspections by the authority during construction. However, it was overruled by the case of Murphy against Brentwood District Council, which is about Murphy having to sell his house at a significant loss because the Brentwood District Council had failed to inspect the house's condition. Murphy then sought to recover the costs from Brentwood District Council, but he failed as the loss was classed as pure economic loss. Therefore, the court overruled the decision from Ants against Merton London Borough Council with respect to duty of care in English law, and decided that the Murphy against Brentwood District Council case was in relation to recovery for pure economic loss in tort. The third one is to reverse. When a case is heard on appeal, a higher court may disagree with the legal principle applied by the lower court, which heard the case first. The original decision gets to be reversed, and a new precedent is created by the superior court to apply to these material facts in future cases. And in the case of Fitzpatrick against Sterling House Association Limited, the Court of Appeal refused to allow the homosexual partner of the deceased tenant to take over tenancy, as he could not be described as family required under the Rent Act of 1977. However, the House of Lords reversed the initial decision by the Courts of Appeal and held that he could, on the principle that the same-sex partner prove the familial link as required by the legislation. The last method is by distinguishing a previous precedent. It is when there is a binding precedent, a lower court may avoid using the precedent established by a higher court if it finds a significant difference in the material facts of the original case and the case currently being considered. The precedent doesn't get followed because the judge can distinguish new case from the previous one. In this way, the lower court can avoid using the set precedent. An example is the case of Balfour against Balfour and Merritt against Merritt. In the case of Balfour against Balfour, the Court of Appeal decided that an agreement made between a husband and wife for him to pay her £30 a month was not a legally binding agreement that could be enforced by the courts. There was a principle under a domestic agreement that, unless otherwise stated, agreements between husband and wife are not intended to be legally binding. The wife then failed in her claim, and in the case of Merritt against Merritt, a husband and wife had separated and he agreed that he would sign over the matrimonial home if she continued to pay the mortgage. She did, but he refused to sign it over. He relied on Balfour and Balfour, claiming that their agreement was not legally binding. The court, however, distinguished Balfour against Balfour and disagreed with this argument using the principle under commercial agreement that because they had already separated, they had intended to create a legally binding contract. This was a new and a distinct precedent, which now exists alongside Balfour against Balfour. Therefore, the case of Balfour and Balfour was distinguished by married and unmarried.
Wow, that's interesting. I wonder if there are any other exceptions. I'm out of friends. There's only one thing left to do. Hi, my name is Lishan and I'm going to be talking about the other methods judges can employ to use in cases where a precedent is already present. So there are some other methods that judges can apply in cases to avoid breaking the rule of stare decisis. This includes the practice statement of 1966, where originally, except where the decision was made per inquirium in error, the House of Lords was bound by its own previous decisions. In the practice statement, the Lords said their lordships nevertheless recognise that too rigid adherence to precedents may lead to injustice in particular cases. They proposed to modify their present practice, and while treating former decisions of this House as normally binding, to enable them to depart from previous decisions when it appeared right to do so. So an example case that invoked the practice statement is the British Railway Board versus Harrington in 1972, and Addy versus Dumbreck, both House of Lords cases. In the case of Addy v. Dumbreck, the defendants owned a coal mine that had a fence surrounding it. It had a hole that was never fixed that was used as a shortcut to a railway. A child was killed when they climbed onto a hauling machine, and the courts held that there was no tort as there was no duty of care owed to the child. In the British Railway Board vs Harrington, however, a 6-year-old boy was electrocuted and suffered severe burns when he wandered from a play park onto a live railway line. The railway line was surrounded by a fence, but the part of the fence had been pushed down and a gap was created and used frequently as a shortcut to the park. The defendant was aware of the gap in the fence, which had been present for several months, but had failed to do anything about it. Under the existing authority of Addy v. Dumbreck, no duty of care was owed to trespassers. However, the House of Lords departed from their previous decision using the 1966 practice statement and held that the defendant railway company did owe a duty of common humanity to trespassers. There is a second exception in Young v. Bristol Irving Company. This was an English court case that was established that the Court of Appeal is bound to follow its own decisions and those of courts of coordinate jurisdiction, except in cases where 1. The court is entitled and bound to decide which of two conflicting decisions of its own it will follow. So if there are two Court of Appeal cases that have decisions that are the same, in cases such as Holman v. George Eliot, which saw conflict in several earlier decisions, most notably Doyle v. Kaufman and Hewitt v. Barr, the court is allowed to change their own decisions. The second one is the court is bound to refuse to follow decisions of its own, which, though not expressly overruled, in its opinion, cannot stand with a decision of the House of Lords. This means the courts can refuse to follow any decisions that was made by the Court of Appeal that is inconsistent with general principles laid down by House of Lords. And the last one is the court is not bound to follow a decision of its own if it is satisfied that the decision was given per inquirium, where a statute or a rule having statutory effect, which would have affected the decision, was not brought to attention of the earlier court. Basically, it means that this court can defer on decisions which have erred in law. So in conclusion, the doctrine of stare decisis is a really crucial part of English law.
Though it has some issues, but it should remain to uphold the
Certainty of law.
of law.
And that's all from us. Thank you.